Good afternoon. Happy Saturday. We've got a new filing from Jose Maria Small D de Castro. This is a summons for Joshua Abrams et al. This is the civil cover sheet. It's interesting that he reused this from someone else. County of residence, Miami-Dade. Like, how did you get that wrong? You can see there's a box here for U.S. government plaintiff, box for U government defendant, and a box for diversity. There's none for federal, so somebody had marked federal jurisdiction at one point and then widened it out. He's claiming that the citizens of this state for diversity jurisdiction are Josh Abrams and et al. What's her name? Kate Peter. He's claiming he is a citizen of another state. Instead of putting an X in the box, he put a he put a box around assault, libel, and slander. You could see at one point in time he had other civil rights checked, and he had to white it out. So that's pretty good. At some point in time, somebody was demanding 1.7 million? Or was that 4.7 million? That was 4.7 million. So now he's demanding 1.9 million. I'm sure he'll get it. He has demanded a jury. I'm not sure that's entirely the smartest maneuver he could have made. He's not a very sympathetic plaintiff. You can see that he had to white out the original cause of action that he had checked in box 2. and he circled the new cause of action but didn't check the box, so that's pretty smart. Underline all of the parties in this action, excluding governmental agencies of the United States and the Commonwealth of Massachusetts, residing in Massachusetts, reside in the same division? He says no. So he's saying that there's 3 divisions in the Federal District Court of Massachusetts. So if yes, and he marked no, in which division do all non-governmental parties reside? And he checked Eastern Division. If no, where did most of them reside? He checked Eastern Division. So anyway, there you go. Pro persona Jose de Castro. He's keeping his pro persona deal going on. Like I said, usually in federal courts they refer to the plaintiffs that don't have attorneys, parties that don't have attorneys, as pro se litigants, but whatever. By the way, these documents are all courtesy of Desert Sentinel, so thank you, Desert Sentinel. So this is Jose Maria de Castro, a.k.a. Chillie de Castro, a.k.a. Delete Laws, plaintiff, versus Joshua Abrams, a.k.a. Accountability for All, and Kate Peter, a.k.a. Masshole Troll Mafia, defendants. That's pretty good. It's complaint for defamation. Now, he does also allege intentional infliction of emotional distress. The plaintiff, Jose Maria de Castro, hereby brings this complaint for defamation against the defendants Josh Abrams and Kate Peters and states as follows. Facts. The plaintiff's YouTube channel is named Delete Laws. Defendant Abrams' YouTube channel is named Accountability for All. And then there is a footnote. 1. Defendant Abrams apostrophe, wow, that's awesome. Abrams' YouTube channel features videos of defendant Abrams entering limited and non-public forums, libraries, child and protective support service facilities, city halls, post offices. So at least he knows that post offices are non-public forums. Congratulations. To film employees and visitors in purposeful violation of facility policies prohibiting filming. Defendant Abrams then refuses to leave the facilities when commanded, refuses to cease the filming, and publishes to his monetized YouTube channel the controversial employee and visitor reactions that his filming triggers on video. The defendant publishes the contact information of the employees and visitors that he films for the defendant's YouTube audience to overwhelm with threats of violence and sexual violence. This is what you call an attempt to poison the well. Now, against a judge, none of this is, to the best of my knowledge, going to be very effective. It's not relevant at all to the proceeding, and just because he alleges it in his complaint doesn't mean that it's going to make it into the actual lawsuit. As a footnote, none of this is relevant to any of the causes of action that he has. Defendant Peters's, is it Peters plural? Is it last name Peter or Peters? Because that's Peters apostrophe S. Wow, excellent. YouTube channel is named Masshole Troll Mafia with a number 2 up there. So this is footnote 2. Defendant Peters's YouTube channel usually features live streams and videos of Defendant Peter truthfully providing previously unknown but sensitive and revealing information about First Amendment auditors and sovereign citizens. Defendant Peter uses her, in quotes, troll mafia, end quote, YouTube subscribers and viewers to economically, psychologically, and emotionally debilitate her usually deserving targets. However, Defendant Peter, in quotes, went rogue, I don't know who he's quoting there, on the plaintiff and exploited the power of her YouTube channel to defame the plaintiff when all else failed Defendant Peter in resolving her personal disputes with the plaintiff. That's powerful stuff right there. Both the plaintiff and the defendants earn their full-time income from their YouTube channels and websites. From January 2022, the date that the plaintiff created his YouTube channel Delete Laws, to May 22, 2022, the date that the defendants began defaming the plaintiff's YouTube channel views, watch hours, subscriber growth, YouTube like to dislike ratio, YouTube revenue, and website revenue were growing between 10 and 20% per month. The plaintiff was, at all times material, on a meteoric rise to popularity. Meteoric. You heard it here, folks. Meteoric. On May 22, 2022, Defendant Peters live streamed a video to her YouTube channel. Defendant Peters. Is her last name Peters now? Or is it Peter? I don't know. Defendant Peters live streamed the video from her home address. The title of the video is Chillie de Castro once sold the date rape drug and might be a snitch. Will sue us for mocking him. That was quite the prescient title. I think they nailed it with that title. So, good job, Defendant Peters, or Defendant Peter, whichever one it is. The link to the video is, there's the link, Defendant Peters's live stream live stream video generated over 1,100 views. 1,100. Or 11,000. 11,000. Yeah, I'm a lawyer, not a mathematician. Almost 300 comments. And over $1,000 in revenue for Defendant Peters. In the video, Defendant Peters published the following defamatory statements about the defendant. Did you know Chillie was arrested for manufacturing and with the intent to sell the date rape drug? Interesting. I've read some very interesting records that I'm not at liberty to share in public right now, but let's just say I know the circumstances of several of the circumstances of the restraining orders taken out against Chillie de Castro. I know of one, no two, restraining orders that are lifetime against Chillie de Castro. Interesting. The third defamatory statement is, I'm very dogged. Looking into his past, what appears to be a pyramid scheme, definitely these products. So the first one I just want to point out before we move on says, do you know? See, this is a question. Do you know? Question mark. That's not a statement. That's a question. I've read some very interesting records. Now that's interesting. She's not saying that it's her personal assertions. She's saying that she's read interesting records that lead her to know of 2 restraining orders. That's interesting. She also says, looking into his past, what appears to be a pyramid scheme. That's a statement of opinion. Interesting. So let's move on to Defendant Abrams. On June 10th, 2022, Defendant Abrams live-streamed a video to his YouTube channel. Defendant Abrams live-streamed the video from his home address. The title of the video is Delete Law's Truth! Lackluster and James Freeman join. The link to the video is, and then there's the link. Defendant Abrams's live stream generated over 17,000 views, almost 700 comments, and over $1,000 in revenue for Defendant Peters. Interesting. I did not know that Kate and Josh were in that kind of a relationship where Kate could generate revenue off of Josh's comments. That's pretty interesting. The more you know. In the video, Defendant Abrams published the following defamatory statements about the plaintiff. That's interesting. Josh Abrams got a lot more views than Kate. He's more popular. Wait a minute, we missed... Oh, I'm sorry. Excuse me. I missed a footnote. So the footnote to I'm very dogged, looking into his past, what appears to be a pyramid scheme, definitely these products. These products are, the plaintiff's products are, the Happy Hammock and the Jock Sock. Fine products, I should say. Definitely worth your money. You should order some for your parents for Father's Day and Mother's Day. So Defendant Abrams published the following defamatory statements about the plaintiff. He sets up these businesses to get monetary assistance from investors and then to apply for lines of credit. But once it comes time to registering for the business, he lets it fall flat and starts a new business and kinda Ponzi scheme, pays back the previous investors. He has a criminal record, stalking, strangulation, multiple restraining orders. Here is a receipt for $386 for the nights in Danvers, Massachusetts that I paid for Chillie's room for 2-night stay. He has so many liens on him. I spoke to the woman at the front desk, and she said this kind of thing could not happen, and that Chillie insisted to use the card. Buddy, you beat a woman. You threatened me with imprisonment. You stole from me, and now you're Ponzi scheming everyone. Now, when we went on recess, he immediately began texting me. I released a video of him beating up a chick. He has this long, substantiated history of blackmailing people. He goes to New Hampshire and tells this guy he needs his house, and he kicks him out of his home. This guy is now at a hotel. He comes back at 6:15 in the morning, and apparently he finds certain paraphernalia. And I will leave it at that. And this guy had a total meltdown and kicked Chillie straight out of his home. Okay. Chillie found some investors in his app. So I'm sitting in the car with Chillie. He's talking to his cousin about making this app and has this big investor who is going to invest in it. And his cousin is saying, like, realistically, that's not going to work. YouTube isn't that simple. You're making a really complex issue into something simple, and it's not. And then Chillie said, oh, we don't need to create the app. We just need to make it look good for investors. So he speaks to this investor who says, I will toss you a large sum of money, which he wound up sending him, if you can actually produce this app and show me what it is. Later that night, he has an extension cord hooked up, and he's showing you a skeleton version of Google Maps with little pillow poppers on it, purporting to be an actual application that in no way, shape, or form actually exists. That's what a con does. So those are apparently allegations that Abrams made in his live stream on June 10th, 2022. Now, a lot of them don't appear to be defamatory. Like, here's a receipt I paid for his 2-night stay. Now, when we went to recess, he immediately began texting me. I released a video of him beating up a chick. I mean, I think that's a video of him trying to body block Kate. So, I don't know. I don't know why he thinks a lot of these are defamatory. And like this one, he comes back at 6:15 in the morning and he finds certain paraphernalia. You're gonna be hard pressed to say that's defamatory. But anyway, on June 10, 2022, defendant Peter or Peters, we still don't know, appeared in defendant Abrams's live stream and published the following defamatory statements about the plaintiff. Here is what I know. He tends to start a lot of these corporations, LLCs. He immediately lets them fall apart so they get administratively suspended. He'll incorporate, and then he'll never file an annual filing. So the business falls apart. He's using it as a front to get investor money and then apply for lines of credit on products that never come to fruition. He's using the money from the he's using the money from the next product that's never going to happen to pay back the previous investors. Then talking to multiple other people. He also employs extortion, blackmail, and threats. Well, that is possibly defamatory. Saying someone employs extortion, blackmail, and threats, that's accusing them of committing a crime. So that'll be interesting. From May 22nd, 2022, the date defendant Peter began defaming the defendant. Bleh. From May 22, 2022, the date defendant Peter began defaming the plaintiff, to August 2022, the plaintiff's average views per YouTube video on the plaintiff's channel declined from 28,000 to almost 0. The plaintiff's average watch hours per YouTube video on the plaintiff's channel declined from over 4,000 to almost 0. I don't want that. I want Social Blade. Oh, well, we'll see what this is. Oh, he's on a downward trend. That's not good. And the dogs are borking. Views. So it appears that he must have deleted a video or something. So it appears he's not getting almost 0 views. He's still gaining subscribers. Well, that's interesting. Well, that's interesting. Well, that's super interesting. Where does it say is? Interesting. Somewhere in here, I thought it showed. Here it says he has 4.8K subscribers. So, maybe this isn't accurate. Okay. Okay, maybe it's not accurate. That would be interesting, though, if he was buying them 100 at a time like this shows. That would be interesting. All right, so his average views per YouTube video declined from 28,000 to almost zero. Well, we could do this. We could do this, and 1.5, 1K, 6.6, 2.9. They're not zero. I mean, he's hard pressed to get down to zero. And it could just be that people got tired of his shtick. I mean, you never know. It's going to be interesting to see how he proves to do May 22nd, 2022. All right. So May would be about 4 months ago. All right, so we're back in the 4 month area. So let's say 10, 9, 19, 8, 15, 8. So I'm not seeing his claim being like 5.3, 12, 5.7. I'm not seeing, I haven't seen 28. Here's 25, that's close. 4 months ago, audit part 2. Get it, straight jacket. So we're looking for 28K, and I'm just not seeing it. I'm not seeing it. I'm seeing 6 to 10 is average with highs in the high teens. 6 to 10 average with highs in the high teens. Here's $40,000. Warning graphic. Clickbait. Yeah, so 3 months ago would be somewhere around June. So this might be from the end of June right here. So that might be from the end of June. But so I'm not seeing a huge change in his views. Here's 20K. I'm sorry, I'm not trying to debunk him. All right, so we're going to get back to this, but it's just if you're gonna make claims like this to say almost zero, 20,000 almost zero, you probably actually should take the time to do the math, Okay, so the plaintiff's average revenue per YouTube video on plaintiff's channel declined from over $120 per video to almost zero. And so if we're looking at this with almost zero, almost zero, almost zero, I would take this third claim with the same amount of skepticism as the first two. But and not that that's my skepticism isn't important to anything, but I have a feeling he did the same amount of work to figure this stuff out. From May 22nd, 2022, the date defendant Peter began defaming plaintiff, to August 2022, plaintiff's average like to dislike ratio per YouTube video on the plaintiff's channel declined from over 95% likes per video to 60%. Okay, that doesn't impact your monetization though, as far as I'm aware. I don't monetize, so I don't know. From May 22nd, 2022, the date Kate Peter began defaming the plaintiff, to August 22nd or to August 2022, the plaintiff's website's gross sales declined from 4,000 per month to 3,000 or to 300. Excuse me. The defendant's statements were complete and entire fabrications. Well, that will be interesting. At all times of material, defendants knew what the entirety of their statements were. They knew that the entirety of their statements were manufactured fabrications. The defendant's statements caused the plaintiff's YouTube and website metrics to plunge. The defendant's statements caused the plaintiff mental and emotional anguish and caused the plaintiff to be harassed and stalked by the defendant's YouTube viewers. Claims. Count 1, defamation. Joshua Abrams. On May 22nd, 2022, defendant Abrams published to his third-party YouTube audience the following defamatory statements concerning the plaintiff. He sets up these lines of business to get monetary investments. We've read it. He has a criminal record. We've read it. Here's a receipt for $386. We've read it. He has so many liens. We've read it. I spoke to the women at the front desk. We've already read it. We 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 read all those. The defendant's defamatory statements lowered the plaintiff in the estimation of defendant's YouTube audience and deterred the defendant's audience from dealing with the plaintiff. He published his defamatory statements negligently and maliciously, caused plaintiff to experience economic loss. The defendant's statements caused the plaintiff, or accused the plaintiff of committing crimes, and defendant's statements prejudiced plaintiff's profession or business. Count 2, defamation. Kate Peter. She lost the S again. I don't know. She published to her third-party YouTube audience the following defamatory statements. We've already read them. He didn't include the one that actually does appear to be defamation, which was the one about the extortion. This one right here, the June 10th, 2022. He doesn't plead. It doesn't matter that he didn't plead it in there because he pled it elsewhere. So, but he forgot. So, he's dumb. So same thing. Then we have the intentional infliction of emotional distress. The defendants intended their defamatory statements to inflict emotional distress upon the plaintiff, or knew or should have known that their defamatory statements would inflict such emotional distress on the plaintiff. The defendant's statements were extreme and outrageous, beyond all possible bounds of decency, and were utterly intolerable in a civilized community. The defendant's statements caused the plaintiff distress. The distress inflicted by the defendants upon the plaintiff was severe and of a nature that no reasonable man should be expected to endure it. Counts 5. Both Abrams and Peter, punitive damages. The defendant's statements were published maliciously and with a reckless indifference to the plaintiff's rights. To his rights? Interesting. Prayer for relief. Monetary damage, $250,000 per defendant. Compensatory damages, $350,000 per claim per defendant. Punitive damages in the amount of $350,000 per claim per defendant. Cost of litigation, other equitable relief. Well, let's deal with the easy stuff first, because I like dealing with the easy stuff first. He's suing in Massachusetts for defamation. Even though he's in federal court, they're going to use Massachusetts defamation law. And as you may notice by the highlighted text here, this is Section 93. It's like they call it something like GBL. I don't know. They have a weird citation method that I don't really understand. But in no action of slander or libel shall exemplary or punitive damages be allowed, whether because of actual malice or want of good faith or for any other reason. So as far as punitive damages for the defamation, it's not going to be allowed. Now, a plaintiff, this is a Massachusetts case, a plaintiff in a successful defamation case is entitled to fair compensation for actual damages, including emotional distress and harm for reputation and any special damages that have been pleaded and proved. Punitive damages are prohibited even on proof of actual malice. Generally, a reviewing court should not disturb a blah, blah, blah. We concluded that, I think I had this up here because of the punitive thing. So, yeah, that's why. Punitive damages are not allowed. It's in the case law as well as in the statutes for the defamation. That's really what I was going The next thing. So, oh yeah, that's where I was going with this one. So the monetary damages, I think he's trying to say special damages. Special damages are the things that you can actually produce a receipt for. I don't know what he's going to be able to produce a receipt for. He's going to have to show that the causation of their statements, of Kate's statements and Josh's statements, and a direct link from those to any decline in his revenue. So I don't think at, what did he say, $120 a video, that he's going to be able to show $250,000 per defendant. That's going to be tough for him to prove. He will actually have the burden of proving those damages. And he'll have to prove those by a preponderance of the evidence, 51% to 49%. He has to prove them. Compensatory damages. Now, compensatory damages are another way of saying general damages. General damages are for the intangible things, the things you don't get a receipt for, like pain and suffering, loss of consortium, humiliation, things like that. So it's okay for him to plead these, because these are a little more. I mean, they are whatever a jury says they are, basically. Now, generally speaking, a jury's not going to give you a lot of compensatory damages if you don't have a lot of specific damages. You generally don't get a lot of general damages if you don't have a lot of specific damages. And the reason for that is because, like, let's say you were injured and you go to the doctor and you spend, like, between your copay and your insurance, you spend like $200, and the doctor says, well, you have a mild bruise, a contusion, or whatever they call that. So here's a prescription for aspirin or whatever. The amount of pain and suffering that you can have for that particular injury can't be that much, because the doctor didn't have to do that much to fix you. There can't be a whole lot of pain if you only get aspirin. Now, it also does cover things like humiliation and emotional distress and things like that. But generally speaking, the specific damages are kind of the baseline, and general damages are going to be some multiple of it. So this is going to be whatever money he actually can prove that he lost as a result of what Kate and Josh did. This is going to generally speaking, be some multiple of this, generally. Now, we know punitive damages are out for the defamation claim. Theoretically, he could still get it on a intentional infliction of emotional distress claim. But the emotional distress here is the same as the emotional distress in here. It's just he's saying that they're doing it intentionally. And we'll deal with that. So with mental suffering, the plaintiff is entitled to recover for the stress and anxiety, which may have been the natural result of the legal wrong. They have to recover for their mental feelings, which are the natural and necessary result of the defamation. However, if a plaintiff cannot prove damages but can prove libel, the plaintiff is only entitled to nominal damages. Now, why are we talking about this? One who's liable for libel is liable for at least nominal damages. And imputation of a crime is defamatory per se. So because they said these things, because Kate and Josh said these things, it's assuming that they don't have any defenses, assuming that he shows that these are actually libelous statements, because they said them, he's automatically entitled to nominal damages. Like, here's your dollar for winning, right? Assuming they don't have a defense or privilege. So if he can't prove special damages, if he can't prove the loss of money from his YouTube or his sales from his store, from his website, then he's still limited to nominal damage. So if the nominal damages are $1, then the compensatory damages are that $1. You don't get compensatory damages on top of the nominal damages. And again, for the intent, or for the defamation, you don't get punitive. So that's a problem. One other thing that is also a problem is it's always fun and dandy to put these gigantic dollar amounts on lawsuits, but it doesn't really mean anything. You're going to get the money you're able to prove at trial unless there's a settlement. And strangely enough, I don't foresee either Kate or Josh settling this. I don't see it. It could happen, but I don't see it. But assuming arguendo, let's just as a thought exercise, just assume that, like, let's say Josh and Kate default, and let's say that Chillie can actually get a judgment for $1.9 million. Let's just say he can't. Arguendo. Josh and Kate don't have $1.9 million between the two of them. And they have access. It's very hard to collect debts from individuals. It's very hard to do. He's going to have to try. He's going to spend a lot of time and effort. And I know this because I do this fairly regularly, to garnish their wages. But if they make money from YouTube as 1099, then that's going to be kind of hard. I don't know how he would do that. I assume it's possible, but we'll see. He's going to have to try to find their employers. He might have to put liens on their houses and things like that. I mean, it's going to be hard for them to collect, and they have a lot of ways to shelter themselves. Like, I'm assuming they have homestead laws out in Massachusetts. They have bankruptcy in Massachusetts. I mean, if they owe more, if they owe $1.9 million to Chillie, then they could probably declare bankruptcy and protect most, if not all, of their assets. I don't foresee either of them having the kind of assets that would be in excess of what they could protect with bankruptcy. So keep that in mind. So then there's the question of, are they news reporters? Are they reporting the news? Because there is a privilege. It's a privilege. It's not defense. It's a privilege to report on judicial stories, like things that happened in court. And some of the things that they're talking about are legal proceedings related. Like so arrested for manufacturing. This is going to have something to do with the legal system, with courts. Was he? I mean, if it's on his criminal record as an arrest, then that's something that would be subject to this privilege. And so it has to be fair and accurate. It doesn't have to be true. It just has to be fair and accurate reporting. So in this instance, is if someone made a claim in a legal proceeding, i.e., like to a cop, and they arrested Chillie for manufacturing with intent to sell. See, what they're saying here is he was arrested for it. They didn't say he did it. They said he was arrested for it. So someone made the allegation. So them reporting on it would come within this privilege. And it includes records of all indictments, arrests, arraignments. They're reported without liability. So it doesn't even have to be precise, as long as it's like kind of fair and accurate. It gets the gist across. So maybe it wasn't the date rape drug. Maybe it was some other drug. Maybe it was meth or steroids, or who knows? Like, and maybe it wasn't manufacturing, maybe it was just possession with the intent. As long as it's kind of fairly accurate, gets the gist across, it's going to be covered by this particular privilege. Oh, yeah. So, in order, another thing is whether or not this is a matter of public concern. Now, it's also a matter of whether or not Chillie is a public figure or a limited public figure. You could make an argument either way, and I'm not going to say which way it's going to shake down because you could make arguments either way. On the one hand, Chillie tries to hold himself out. You know, he was having a meteoric rise in fame on YouTube. I think he used the word meteoric. He has an IMDb page. He holds himself to have been an actor with what's that show, Power Rangers or something like that. There are things that make you think that he might be popular. For example, I've been trying to struggle through this video from the frog, and it's not because of the frog, it's because of the sovereign citizenry that's going on in it. But he gets invited on to panels with other YouTubers. He's been on panels with James Freeman, who has a very high number of subscribers. He holds himself out to be a leading figure. There was something about his TikTok channel or something where he had like a huge TikTok channel. I'm not entirely sure. But anyway, so the question is it a matter of public concern? And is he a public figure or a limited public figure? And if it is a matter of public concern, or if it is a matter of, or if he's a public figure, then you can't get presumed damages without showing actual malice. I'm sorry, I was distracted. So you can't get presumed damages. You can't recover without showing actual malice. I thought I had something else on this, but I don't remember what it is, and I got distracted, and I'm sorry. So, the actual malice standard. What Chillie will have to show if he's found to be a limited public figure, or if it is a matter of public concern, is he'll have to show that Kate and or Josh acted with actual malice. And actual malice doesn't mean what you think it means. It means that they acted with reckless disregard for the truth or falsity of the statements that they were making. And that means basically they knew or they should have known that it was false. Now, he alleges that they knew that the statements they were making were false. Let's see. Somewhere in here, I thought he said that they made them. Somewhere in here, he says that the statements they made, the defense statements were complete fabrications, and they knew that their statements were fabrications. So he is alleging that he's alleging that they acted with actual malice, but he actually has to prove it. And he has to prove it not just by a preponderance of the evidence. He has to prove it by clear and convincing evidence. It's essentially the civil version of beyond a reasonable doubt. It's a very high burden of proof. And it is a burden of proof that, generally speaking, you can't show. That's if you wonder why political figures they get defamed all the time. They get defamed all the time, and the reason why they don't sue on it is, number one, it's really hard to recover this stuff. That's number one, and number two, because they're public figures, it's really hard to prove actual malice. It's almost impossible. You have to show it by clear and convincing evidence. Now, the other issue, the other big elephant in the room, is the intentional infliction of emotional distress. In order to show intentional infliction of emotional distress, he actually has to prove that they acted, that their actions, in this case he's saying their statements, their words, were extreme and outrageous, beyond all possible bounds of decency, and were utterly intolerable in a civilized community. Those words have meaning. We've held that, with the exception of let's take one step back. So this case, Howell, stands for the proposition where if you lose on the defamation, if you don't show the defamation, or if the defamation was shown to be privileged, then you can't get intentional infliction of emotional distress. If your intentional infliction of emotional distress is based on the same statements that you're saying are defamatory, if you lose on the defamation, you lose on the intentional infliction of emotional distress. So he's gonna have to deal with that. If he loses on the defamation, he loses on the intentional infliction of emotional distress. So as far as the extreme and outrageous, it means that, for example, a high order of reckless ruthlessness or deliberate malevolence that is simply intolerable. It has to be profoundly shocking conduct. And the reason why is that they accepted that if you're going to have intentional infliction of emotional distress without a showing of physical harm, then the door to recovery should be opened very narrowly and with due caution. And the way that they protect against that is to require that the defendant engage in extreme and outrageous conduct. Liability cannot be predicated upon mere insults, indignities, threats, annoyances, petty oppressions, or other trivialities, nor is it even enough the defendant has acted with an intent which is tortious or even criminal, or that he is intended to inflict emotional distress, or even that his conduct has been characterized by malice, or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Rather, liability has been found only where the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. So, for example, something that would be this level of intentional infliction of emotional distress would be if someone, let's say a husband who's going through a divorce, who shares a lot of friends with his wife, who's also going through the same divorce, obviously. If he were to, say, for example, publish publicly onto his Facebook account to his friends who he shares with his wife, that his wife has the odor of fish emanating from her groin, in more candid terms, that would be something where you might be able to get intentional infliction of emotional distress. Something like that is so far out of line. Even if you like husband, even if you think husband's a cool dude and you understand he's having a bad day, you know he shouldn't say those kinds of things because it's just hurtful. It's beyond the pale of what our society will accept. It's extreme. Saying that someone was arrested for manufacturing and selling drugs, not as extreme. Saying that someone committed a crime that they didn't commit, not as extreme. Because remember, just because you could say you're alleging someone committed a crime like fraud or blackmail or anything else, doesn't in and of itself make it that level of extreme. It has to be extreme. It has to be so extreme, so outrageous that society won't accept it. And society accepted what, it's just, you can just tell that society accepted what Josh and Kate were saying because they got a lot of views and they got a lot of likes. I don't remember exactly where it talks about it, but I think she got at the time he filed, or the time he prepared this. I'm assuming it's correct. Let's look at it. All right, so it was May, so about 4 months ago, roughly. April, so no, not this one. May 22nd. So he said 13,000 views. 11,000 views, okay. 11,000 views, 300 comments. So maybe he got that amount right. So anyway, I don't think he's going to have a lot of success on showing the intentional infliction of emotional distress. Now, here are some other fun things that are going to happen. He's made claims. He's made claims about the impact of these things on his YouTube channel and on his store, on his website. Let's see where he made these claims. All right, so he's going to have to show in discovery, assuming they actually get to discovery, Chillie will have to produce documents that show his gross sales averaging $4,000 a month before May 22, 2022, down to, and he's going to have to show his gross monthly sales off his website averaging $300 per month from that date. He's going to have to show his like to dislike ratio and how that changes over time. He's going to have to show it. He's going to have to show, here's a fun thing, he's going to have to show his average revenue per YouTube video. He's going to have to prove that he was making $120 per video, and he's going to have to show he's now making $0 per video. Another fun thing is, I'm guessing California makes it this way. In California, compensatory damages, just because like your defamation, you have experienced some emotional distress from the defamation, that doesn't open anybody up to getting a medical exam. You can't say, you know what, I need you to submit to a mental evaluation because you're saying that you had emotional damages as part of your compensatory damages. But once you make a statement, at least in California, about the intentional infliction of emotional distress, you have to prove that there's emotional distress. And one of one of the ways, generally speaking, a plaintiff will prove emotional distress is to go to a psychologist or a psychiatrist and pay the psychologist or psychiatrist money. That will, number one, establish special damages, because those are things that have a dollar amount. Those, every time the psychologist or psychiatrist talks to the patient, they spit out a bill. And the more of the special damages you get, since typically general damages are a multiple of special damages, they tend to be a multiple of special damages. The more visits you go to the doctor, the more money it costs, the more you can show that it actually hurts you. But one of the things that it does, at least in California, again, I have not verified this for Massachusetts, is if you do intentional infliction of emotional distress, you are specifically alleging that emotional distress, not general emotional upset, but actual quantifiable emotional damage to you, emotional distress. And in California, that puts your mental state at issue, and they can get you can basically subpoena them to a mental evaluation, so that your expert can evaluate them to see if there actually is emotional distress. Just like with a personal injury, the same thing with personal injury. You can't do a mental evaluation, but you can do a physical evaluation because they've put their physical health at issue, and so your expert can examine them. So there are definitely some issues here. I'm not saying it's clear cut either way, but right now Chillie has a pretty big mountain to climb. Sadly, Josh Abrams and Kate Peters, I don't know which it is, are going to have. They're probably going to have some expenses because they're probably going to want to hire an attorney to make sure this gets shut down right. But we'll see. We'll see. So, there was one other case that I read, and I don't think I have it linked up here. It was Downey. This one right here. So in this particular case, the defendants basically said that there was a case of water damage under the roof, and somebody had installed the roof, and they said, well, the roof wasn't leaking. We examined the roof; it wasn't leaking. We did cuts to determine blah blah blah, and we examined the roof, and we didn't find any evidence of leaks. So the only way this could have happened would have been if the roof was put on a wet ceiling, if the underside of the roof was wet when the roof was installed. He reported the roof had been installed a number of years earlier over fiberboard roof insulation that was soaking wet, thereby causing water damage. So they were saying that the roof insulation was already wet when the roof was installed. And that was apparently defamation, right? But they had a reason for it. So because they said the facts on which they based their opinion that the roof was installed over wet insulation, the fact that they said the roof was installed over wet insulation, which sounds like a fact, actually wasn't. They were showing you their work. And if, for example, I did watch the Kate Peters one. I watched their live stream, and if I remember correctly, she showed various documents or said where she got the information from. So she showed things, and she stated the grounds under which she was making these allegations. So see, she's showing the things. So that is a defense for her. Anyway, I've rambled long enough. Thank you for watching, and have a great day.